Hey, this is Elizabeth Potts Weinstein, and today we're going to talk about, do you need a trademark as a small business? So first let's talk about what's the difference between a trademark and a copyright. Copyright law protects creative works, and trademark law is protecting trade names. So how that typically breaks down for businesses is copyright law is protecting books that you may write, audio recordings, videos, the content of your website. Well, trademark law, that's protecting words, phrases, symbols, your logo, could even be protecting a sound. But those types of things that are used in conjunction with your product or service. From the perspective of your clients, of your customers, do they link those together, those words, those logos, with your product or services, with you as the source? So it's not every single word that you use, every name of everything. Like, for example, the name of your business, such and such LLC. It might not be a trademark for your business because maybe your clients or customers don't even know the name of your LLC. It might be on the contract, but if it's nowhere else in your marketing, they don't really think of that LLC name as you, really. They actually think of the name of your website as you. That's really your trademark. Or maybe they think of your tagline as your trademark, or maybe even your personal name as your trademark, but not the LLC name. So it really depends on that context is what is the trademarks of your business. And it has to be used in conjunction with a product or service. And typically we're talking about things where you've made sales. There are places where we have an intent to use trademarks, so you haven't yet actually made any sales, and so we file an intent to use application, but eventually you're going to need to use it to prove up that use. So we're talking about where you have some kind of trade name, some kind of logo that you've used in commerce to make money. Like I was saying, the purpose of trademark law is to protect customers, the consumers, the clients, and everything is from that perspective. Yes, it does give you an asset. It does also protect you as the business owner, but everything's from the perspective of the consumers. So it's important to always remember that because that's how the laws are drafted. So if you remember that, it'll help you understand why everything goes the way it goes. Now, in the United States, how the law works in trademark law is it's at two different levels. One happens automatically. In states, and of course this is all 50 different states, you get automatic trademark protection as soon as you're making sales in a particular state. But how it works depends on the state, and how much protection you get depends on the state. And of course, you have to make sales in each state to get that protection. So if you're here in California and you're making sales in California and someone else starts a business with the exact same name in New York State, that doesn't help you, right, to go after them because you only have protections here in California. You haven't made any sales yet in New York State. And most businesses that are really small in the beginning don't make sales in every single state. You may have a website, but you haven't yet made sales in North Dakota and Alaska yet. Okay, so that's a problem. So the idea of getting a federal trademark with the United States Patent and Trademark Office is you get protection everywhere. But it costs some money and time. You have to file an application, and there's an examiner at the Patent and Trademark Office that goes through an approval process with you, and some of them get denied. So it's just something to be aware of. It's not automatic. So why would you even want to go through that process? Well, I mean, obviously, besides the whole idea of it getting protection over all the states, which I already mentioned, one of the big reasons that a lot of my clients do this is because they want to license or sell that brand or the entire business. So let's say you're a coach or a consultant and you want to license other coaches or consultants to be the such and such coach, or you want to take your program and license it to corporations to train their employees. Maybe you're developing an app, an iPhone app or an Android app, and you want to sell that app to some other company. Having a registered trademark gives you one more asset to sell, one more asset to license as part of that package. Another reason is defensive, especially if you're risk adverse, you may someday get a cease and desist letter from somebody saying that you infringed their trademark. Well, if you have your own registered trademark, that completely changes that calculation because now you have something to defend yourself with. Now, there's a couple other reasons, even more than I've listed here, that are more legal technicalities. It shifts the burden of proof. Your trademark will become incontestable after 5 years. The bottom line is, if you have a registered trademark, it makes it much easier to stop other people from infringing your trademark. It's not automatic. You still have to police it by sending cease and desist letters. You may even have to sue somebody, but it's much easier to do that with a registered trademark than it is under state law. So what should you do about this? Because you're not going to file for a registered trademark on every single name of every program or product that you have, on every single tagline. That's just way too much money. The first place to start is to make a list, though, of all the things that you have, because you have to figure out which ones are important and which ones are going to actually make good registered trademarks, if any. So make a list, brainstorm a list of all your brand names, all the product and program names you have, your taglines, it might even be your own personal name if you use that in your marketing, the name of your business, name of your domain names, the name that's on top of your website, name of a blog, all that stuff. Brainstorm a big master list of all those names. And then just start running Google searches on them. And also run a search in the trademark database. You want to just see what's out there already. Are you infringing anybody else? Is anybody currently infringing you? Like, just the straight answer of what exists today. Then you're going to just start to prioritize. Are there potential problems that are existing right now that need to be dealt with? Any fires that need to be put out? And if not, then you're going to start looking at, okay, what are the most valuable names to you from a business perspective? And then you may also talk to a lawyer about which of these trademarks are going to be the easiest to get through the Patent and Trademark Office from a legal perspective, most likely to get through, which of these are the most valuable from a legal perspective, and kind of compare that with your list from which are most valuable from a business perspective, because that may or may not match up very well. And it's a strategic decision. There's also a lot of risk management issues when you're deciding which ones you should file an application for a registered trademark on. There's not necessarily one right answer. It's something that you need to discuss with an attorney is the best way to go about it. Now, some of you may want to work with someone in person who's in the same town as you. If you want to work with someone online via phone or email, one of the ways you can work with me is via a trademark counseling session. This is where I also do applications, but this is just to get started. One of the things that we can do is I just do a search, and we have a meeting via phone or via Skype or WhatsApp and go through the results of the search, discuss whether or not it makes sense to file a trademark application on this, or use a different way to protect your trademark, because there's other ways you can protect your trademark too, besides registered trademark application, because in some way, sometimes that actually doesn't make sense. So if you would like any more information about trademarks, the difference between trademarks and copyrights, or anything else about intellectual property or small business law, you can go to my website, elizabethpw.com. Or if you have any other questions about trademarks, you can also email me directly, elizabeth@elizabethpw.com. Thanks a lot, you guys. Bye-bye.